Thank you, Bruce. On those ABA reports, just to show that this is a mainstream, very conservative bar association, hundreds of thousands of members, and Michael Greco, who is president of the ABA, he's a lawyer downtown in Boston, in 2005, 2006, assembled a team of lawyers who were Republicans, Democrats, worked for the NSA, FBI, CIA before they retired into private practice, and sent 3 white papers to President Bush saying that he was behaving unconstitutionally, as Bruce said, unlawful surveillance, signing statements, and imprisonment without charges. And it didn't create a ripple. The White House never even replied. And apart from an AP report, it got virtually no attention and had no reaction in the law schools. Now, I think we're entitled to begin applying sober psychiatric principles to what's happening to our profession. When the Maine Bar Association charges in somber words the President of the United States with recidivistic, unconstitutional behavior, and nothing happens. Congress doesn't pick it up, press doesn't pick it up, profession doesn't pick it up. There's a lot more to come, and those of you who would like to text message your friends and tell them to come on over, it's not that long a walk from the dorms or the schools, classrooms. Encourage them to come over. Our next speaker is Ramsey Clark. Ramsey Clark is a historic figure of moral and physical courage for his pristine pursuit of human rights and the rule of law. From the terrible victims of criminal sanctions, and those sanctions killed over 1 million Iraqis, many of them children. That's a violation of international law. From the terrible victims of criminal sanctions and wars of aggression, by definition are criminal under international laws, to the defense of notorious despots as the necessary way to uphold the rule of law. You can't find anybody more strictly pristine than Ramsey Clark. It takes a lot of fortitude to be at that range of activity. As Attorney General of the United States in the late 60s under President Lyndon Johnson, Mr. Clark had to advance both the great civil rights reforms as well as prosecute anti-war activists as the president's lawyer. After his years at the Justice Department were over, I had the sense that never again would Ramsey Clark ever leave for work day after day without his fierce and independent conscience. Having been to many of the most dangerous hotspots in the world as a lawyer, advisor, and author for peace and justice, he continues as one of the most fearless and consistent faces of justice, necessarily controversial in American history. I urge you to read his book, The Fire This Time, to see the difference between realities on the ground and the widespread practice of government lying to its own people as a mechanism of control. The book Killing Hope illustrates how many times our government, after World War II, overthrew regimes and subverted elected officials, all along justifying it as a struggle against communist tyranny. Killing Hope takes every single one of those violent overthrows and documents them. I want you to judge for yourself the following episode here at the Harvard Law School. In the fall of 2011, John Brennan came to the law school. He was a special anti-terrorist advisor to President Barack Obama. You can get his transcript online. Hardly a paragraph went by without him claiming that everything the government was doing abroad adhered to the rule of law, to our Constitution, and to our values. Repeatedly he said that. Repeatedly he prevaricated. But he was received by a full room of Harvard Law School people, led by the dean and all the top brass, and emerged unscathed by any critical questioning. I suggest the following. Given what he was describing, and given the casualties, and given the harm to our constitutional due processes, would he have escaped unscathed if by mistake he emitted a gender, racial, or ethnic slur? Are we prisoners of words, or are we challengers of the cruel deeds that these words represent? Ramsey Clark's subject today is, quote, law and war. Can law be relevant to the human threat to its own existence? Ramsey Clark.
My father wanted me to go to Harvard Law School, but the Siren Song of Chicago and Robert Hutchins and Ed Levy and others led me astray. I just want to say, Dad, I'm here. Finally. It's not the first time, though. It's hard to avoid this place, for better or for worse. Bruce Fines said very eloquently much of what I had planned to say, and we'll try to embellish on it in a perhaps a more broad-scale perspective. This is the 60th anniversary of the end of the Korean War and the 40th anniversary of the end of the Vietnam War. They were big wars. We were good at killing in them. 7 digits in human lives. By that I mean in excess of the million. The happy part of the plant today is that they're thriving. To see both the North and South in both of those countries thriving. You may tend to doubt that about North Korea particularly, but it's, I was there for 5 days and I saw all the cities south of 100 miles north of Pyongyang. I didn't get up north of there. And the children are fat and happy, and the corn is high, and the tables are plentiful. Pyongyang, which was rubble, I mean, it was rubble. It wasn't like the ghetto in Warsaw, which at the end of the war, there was only one building left out in the middle, a Christian church. And the rest was all rubble. There's no church or anything left in Pyongyang, and now it's a new city. A building city and a happy city with lots of children. Since the end of the Vietnam War, we've had 20 or 30, they're a little hard to count, violent interventions against foreign countries. It's almost hard to remember them all. I'll tell you, if you lived there, you remember them, and they were deadly. Perhaps the smallest of all the countries, the smallest that comes to mind at the moment anyway, would be the little island of Grenada down in the Caribbean. It may not seem like that was a very big war, but in one day we killed more of their people than we lost in World War II in proportion to population. You notice that. Everybody on the island knew a number of people, a small island, but had over 100,000 people. They knew people that got killed. And the killing was like all war. When those things were happening, I used to get a lot of calls, still do. And I went down there within 3 or 4 days. You couldn't get on the island. The press didn't get on the island for about a week. But I happened to run across a former student of mine who was a captain in the Air Force. He smuggled me in on his plane. One of the first things I tried to do was get up on the hill behind the Capitol there, because there were several brothers, but one of the brothers of a person who was in the mental institution was on that hill was Robert Cord, who headed for many years the largest public interest organization in Boston. And I got up there, and they were the inmates or patients, whatever you want to call them, were up there all by themselves trying to dig bodies out of the rubble. And the island was left a disaster. People didn't come out of it for years. The trial of 17 people held responsible for the crimes that caused our uplifting human invasion that killed so many people, dominated the scene there for about 10 years, and resulted in actually the erection of 3 gallows and the shooting of 1 woman and 16 men for hanging. That only calls from Sister Teresa and several other prominent religious leaders to the acting prime minister granting of commutations at the last minute. We forget what we do. Iraq is probably the bloodiest, most enduring example of our conduct crushing a people. The cradle of civilization, we call it sometimes. And since January of 1991, they've known no peace, no absence of gunfire, no absence of death to this day in the country now. And there are areas that are more peaceful than others, but there's violence throughout most of the country. There's no security. The good things you look for in life are simply not there and haven't been. Syria is on the scopes now. And the great mosque there, which has had been rebuilt many times in the last 600 or 800 years, has the tomb of John the Baptist, and both Muslims and Christians pray to him, and one of the minarets is named for Jesus. There's a large 17%, they say, but a very large and vital Christian population, a large mixture of religions and peoples. And they fought a bloody struggle for 30 months now. It's killed tens of thousands. And there's no right or wrong in it, it's all wrong. There have to be nonviolent ways for social change. And outside interference has been deadly in every case that I've observed personally, and I've observed all that we've done since I left the government personally. So now we find ourselves preparing for more effective ways of killing people without risk, and more effective ways of eliminating whole societies with a single blast. Spent a lot of money on it, preparing for it, and the American people have to put up their socks and say no more. Just the idea of the drones, the idea of the president deciding whether to fire on what kind of information with the president himself. What's he know? It makes him almost the Lord High Executioner, too. That we would ever subject the head of our executive branch under our Constitution to that kind of criminal responsibility shows how far we've drifted from any rational or human standard on little issues like the life or death of sometimes known, but as often as not really unknown targets. With every person targeted, there have probably been, on, if you average them out, 2 or 3 others that just happen to be in the vicinity of the blast force that got killed. We've had 7 trials, it'd be more than 24 people convicted in the invasions of these air bases where the decision to fire the drone is really made and where the trigger is pulled. They're in typical American cities, just outside Syracuse, an air base, just north of Las Vegas, about 50 miles west of the capital, Missouri. And the officer's sitting in there, and he's watching the screen, and he sees the truck going down, and he sees it stop, and somebody get out, and somebody get in, and he finally decides, now the president says he's deciding to fire, and poof. Or he sees the man go into the house. He doesn't know if there are a dozen people, including 4 children, in there or not. And he decides to fire, and poof, the house goes down, and all the lives that are in it are taken. The hatred it creates is stunning. I've seen a lot of hatred from violence and war. I've never seen any that quite equals the hatred that comes from the realization that from thousands and thousands of miles away, somebody can decide to kill you, your neighbor, wherever you are, whatever you're doing. It creates a sense that they have no value for life, that we have no value for life, the people who do this. Here in our poverty, they take it upon themselves to strike, shoot at will, and kill. The the drones are minor killers. They're criminal. But we have the capacity for destruction on which we spend billions of dollars that is so irrationally sick that you wonder how even those that are only subjectively aware of it. We had a lengthy trial, comparatively lengthy for these cases, because courts hate them, in Tacoma, Washington, on the Trident II nuclear fleet Pacific. And the numbers don't sound big until you see what they can do. There's 60 big, fat submarines. I mean, these things are monsters. And there are just 30 of them, but there are 8 at sea. At least this was the program a couple of years ago when the trial took place. At sea, on alert at all times. And any one of them can target more than 20 centers of human population with a missile range of 12 to 14,000 miles and high accuracy. And a nuclear warhead that dwarfs the bomb that incinerated Hiroshima and Belle D. 2 calibers, usually. The larger one can, they say, leave a crater 50 miles wide. That is, the blast force will knock down everything within a point, 25 miles from a point. And we have 4 of those fleets. They affect people in different ways. One of the 2 co-defendants in the Attica Prison Rebellion of 1971, the bloodiest day on American soil since the Civil War, they said at the time, has been at sea ever since. His dad was Coast Guard, and we got him off, and but he's never settled down. He does have a family and kids. He lives on a boat by himself. And he's in the river between Florida and Georgia just a couple of weeks ago. He didn't realize that there's a Trident nuclear fleet up the river there. And he's in about 20 feet of water and a good size, almost 30 feet steel hull boat. And he feels the boat rocking, going up and down, and he looks out, and it looks like these mountains coming down. And all of a sudden, the waves are coming over his boat, and his boat sinks. He loses everything he has, and it's a Trident II nuclear sub coming out from the base there. The machines are unthinkable and impermissible by any human or rational standard, and yet there they are, and we pay no attention, and a few nuns and priests, because they trespass and catch pneumonia sleeping out because they don't catch them going in, sleeping out there in front of the wharves or wherever the subs are, or very often where they store the warheads. That's usually where they try to camp out. It's amazing how much they can find out about what's going on those bases without first getting on them. We have to stop the use of drones. The American people have to demand it. We have to insist that we dismantle our nuclear war preparations. We've been violating the Nuclear Non-Proliferation Treaty every day since it was signed in 1968. Because Article 6 required that all the parties to it work for the day when not only the non-nuclear countries, but the nuclear countries eliminate all effort to continue, if they have possession, or to obtain possession of nuclear warheads and rid the Earth from the threat of omnicide. And we see no progress. I'm an optimist. I've been accused of being able to walk off the edge of the earth shouting or singing, "We shall overcome." I can't carry a tune very well, but I shout it. But we should overcome ourselves the wrong way if we don't wake up to the obvious that we're on a course of destroying life on a very beautiful planet that was given to us, on which children could grow up happy and healthy and learning and advancing the goodness of humankind. I think that's my time, maybe. I didn't look at the clock. You didn't know you were going to get a sermon from a lawyer, but it happens. Not a very good sermon either.
Ramsey, thank you for your work and for your words. I am interested in two things. I always had a suspicion that there was maybe one thing or maybe more than one thing that happened when you were working at the Justice Department that led you into a different life afterwards, or was there something else that led to the change in direction in your life? And the second thing is thinking about this with Bruce Fine, but you probably as good a person as any to ask this of what I wonder, most of today is about the rule of law and working to change and make more effective the rule of law. I wonder about the efficacy of civil disobedience and direct action. I know you've worked with and represented a lot of people who've done a lot of good work in those ways, but I sometimes wonder, even that is losing its efficacy, and would you care to comment on that?
I'm not sure I heard the answer adequately. Ralph, did you get the question? Could just give me the specific question.
The first is, was there something that happened when you worked at the Justice Department that troubled you so much that you changed what you wanted how you wanted to live your life? And the second question, what do you think is currently the efficacy or lack of efficacy of civil disobedience and direct action?
Mm-hmm. Well, we're all prejudiced just on different subjects, and I thought our Department of Justice did some good things. I thought our work in civil rights was important and meaningful and helpful, and worked. Not only protecting lives immediately, but things like the Voting Rights Act had a revolutionary impact. 7% of the African Americans of voting age in Mississippi voted in '64 and 70% in '68. And we had some hard times. The Vietnam War was a great tragedy, and we didn't accomplish all we could. We called for the abolition of the death penalty for the first time in the history of the department. And for the first time in the history of our country, we had no execution in '67 and '68. Didn't have one until '72, I think it was. I guess Gary Gilmore was the first. But the death penalty is more than symbolic. I mean, if you've got nothing better to do than kill somebody because they've done something hateful, your society is not going to progress very well. And the civil rights movement didn't come from the Department of Justice, but we heard the voices and we helped some. The same would be true of criminal justice. Mayor Daley was calling for shooting looters, and the Department of Justice told him, you shoot looters and you'll be prosecuted. As mayor, including the police officers that shoot looters. You don't shoot a 13-year-old kid for stealing a watermelon or something. That's about what was going on, you know. The Department of Justice can be an important symbol for the country and justice. And sadly, more often than not, it's not been. But during the civil rights period particularly, I think we were doing pretty good. And then with the war and the prosecution of draft evaders, which is heartbreaking stuff. I mean, mothers and fathers coming in and trying to contrive a case that might protect some of them by the Chicago 7, not the Chicago 7, the Benjamin Spock, William Sloane Coffin prosecution. People that can take care of themselves rather than 18, 19-year-old kids from poor families generally. The rest were at Harvard and had a student exemption. Yeah. And your second question.
The efficacy of civil disobedience in the current environment.
Well, I think if people won't put their bodies on the line, so to speak, against their government, when it's engaged in a seriously immoral or inhuman activity, are not worthy of the title citizen. If you love your government when it's doing something that's significantly wrong and continuous, you try to stop it by protesting nonviolently, and you put your body on the line. There's nothing that I've felt more honored by in my life than representing the plowshares groups and others who do that constantly as a way of life. And cumulatively, from one conviction to another, spend some years of their lives in prison. But they do it for us, and they do it to make our government act honorably and in the interest of the people. It's also, it's not power to the people. The power is in the people. I think that's almost a truism. The question is whether the people can find the organizational skills and the will to demand that a democracy act in accordance with the will of the people. And that requires more than civil disobedience. It requires simple things too, like voting, like your life depended on it. Next, another question?
What about demanding, the people demanding the right of to get our political prisoners back? People like Lynn Stewart being prosecuted on a technicality and then being held, and I don't know where down the road they're going to come to the conclusion that they've created a serious injustice, but are getting our political prisoners back. Because when you go out, you know, and demonstrate and everything, there are costs. And increasingly, they've gone after the judiciary, they've gone after our leaders, city councilors, lawyers, people who would represent ordinary citizens, and I just want you to comment, and also organizations.
You know, I'm sorry, but I can't hear the question. Can somebody tell me what the question was in just a few words? It may be the microphone. It's also my hearing, though. I don't hear
Okay.
well.
It was on political prisoners and the costs that we have to pay, and what you think should be done for us to free our political prisoners.
Well, there should be no such thing as a political prisoner, if you define that as being a person who's prosecuted because of her political
Standing
views and acts. And a decent citizenry doesn't permit that to happen in their country. But when it does, you've got to have organizations and individuals who stand up and lawyers. In fact, the first line of defense usually is the lawyers who stand up and say, not in our country. A country that has what we call political prisoners is not a free society and doesn't respect the rights of the individual, which is the basis for every decent society.
She also asked about Attorney Stewart in prison. She also asked about Attorney Stewart. Lynn Stewart.
Lynn Stewart, yeah. We have some beautiful people in this country. Lynn Stewart is a mother and a grandmother and kind of the mother of the earth type, and she is Mother Courage all over. She's a school teacher for years, and she saw some injustice in the courts, and she decided to become a lawyer. And she went into law school and got in the trenches of criminal courts on the defense side and became in some really tough courts that run through a lot of poor people that have a very hard time getting a fair trial. One of the most successful criminal defense lawyers in not only Manhattan, but in New York City and beyond. And then she met me. And the blind sheikh, as he's called, Sheikh Omar Abdul Rahman, he was blind. He couldn't do what he was charged with doing. It was a physical matter. But he was indicted with about 17 or 18 other people in a huge indictment. And for some reason, the judge had not forced the choice of counsel on him. He had no counsel, and there were about 3 months left before the trial was supposed to start. And they were young guys, but they were both heads of different mosques, and one in Jersey and one in Manhattan, came in and said that they were working with the sheikh. They said, he doesn't have a lawyer. He said, will you represent him? I had a court-martial trial at Fort right up in northern New York, where they had the winter war games, and said, well, I'll get counsel. And I thought of several people and talked to them, and then I thought, what a great thing if we get a woman lawyer to represent this Muslim sheikh. And the first name that came to mind was Lynn. She came up one Saturday night, and her husband, Ralph, was with her. We talked for an hour or so, and then the time to decide came, and Ralph stood up and shouted. We were just in our conference room, just the three of us. He said, Lynn, don't do it. And Lynn said, if the judge will give me time to prepare, which no one had at that. You can't prepare a case like that in 3 months. They've been taking depositions for over 9 months and finished them 6 months before this for the other defendants. Well, she went to see the sheikh, and lo and behold, they hit it off. It was one of those wonderful things, because you'd think the sheikh's not going to take a woman, and they became jolly friends, and she became his lead counsel. And as you may know, she was later indicted for a harmless act and convicted. It was harmless in the sense that it could have had consequences, but it didn't. That he'd been placed under, I always refuse to sign an oath. I say, if you don't trust me, I can't do business with you, you know. And if you think an oath's going to make me more honorable than a non-oath, then you don't know who you're dealing with. But anyway, they invented these things called SAMs, Special Administrative Measures. They're about that thick, and they tell you what you're going to have to do if you're going to represent someone like Sheikh Omar. And finally, we all held our noses and eyes and signed them. And Lynn was charged with violating the SAMs, which prohibited you from saying anything publicly that the Sheikh had said to you when you were meeting with him under any circumstances, usually in prison. And I'd said something that his Gama al-Mazia in Egypt, Gama al-Ismailiyah in Egypt was fighting the government this some years ago, and a ceasefire came up, and they asked him publicly that Sheikh Omar, who was in prison in the United States, to express his views on whether he should go for the ceasefire. So I asked the Sheikh, and he said, yeah, I'm for the ceasefire. He was following the thing because he had a radio from Cairo that he could listen to 24 hours a day just by turning it up or down. And I thought, my God, if I don't, if we get a ceasefire, people won't be killed, you know. So I announced publicly that the Sheikh favored a ceasefire, and they were informed, and nobody did anything. And I was in trying a Rwanda case, and Lynn was visiting him, and the question had become whether to continue the ceasefire. And Gama Ismailiyah asked to find out whether the Sheikh favored continuing the ceasefire. And she went to see him, and he heard the circumstances and knew the circumstances from the radio. He said, the ceasefire is not working. They're arresting people, they're killing some of them, and I don't favor continuation of the ceasefire. So she said that, she got indicted. I couldn't believe it. Phone rang one night in Africa where we were trying the case, and they had arrested Lynn, and she was convicted. Right now, she's dying of cancer. She's in the women's prison hospital in Fort Worth, Texas, just on the lake up north of Fort Worth there. I mean, not 5 miles. She's got less than 18 months to live according to their medical people in the prison. And we have an application for compassionate release for Lynn Stewart, who's this great, great human spirit and woman and lawyer. And I thought we had it, but the U.S. attorney to get compassionate release, you have to have the warden of the prison who's given it the approval. You have to have the head of the Federal Bureau of Prisons, and then the U.S. attorney takes it to the judge, the sentencing judge. And that's in process right now, but it's caught in the office of the director of the Federal Bureau of Prisons. And there's a demand from the U.S. attorney that she say she was guilty of a crime and that she's, wants mercy, and that's not Lynn Stewart. She tells the truth. She said, look, I'm here. I want out. I want to be with my family when I die. I'm dying. If you got compassionate release, give it to me. If you don't, don't. But we'll see what happens. Not a happy picture.
Thank you, Ramsey Clark. He mentioned Robert Hutchins, who is president of the University of Chicago. He was also dean of Yale Law School by the time he was 30, Hutchins. I remember he came here when I was 1L, and the whole room was full, and he gave a speech. And the one thing I remember from the speech was he asked the question, what's the purpose of the Harvard Law School? And it was promptly misinterpreted as meaning as a whole, as an institution, instead of its constituent parts, faculty, students, alumni. And there wasn't much discussion of that provocative question. Those of you who think that these assaults on our Constitution, civil liberties, rule of law are justified by the threat of these gangs abroad, it's good to recall a CIA word called blowback. And again, by violent overreaction to events overseas, we've incurred a blowback on our own interests. Afghanistan is a good example of that. And what some national security people are now fearing is the next stage blowback will be in this country in terms of what we're seeing in other countries coming to this country. And one national security person told me there is no defense against those kinds of suicide bombings. Zero. So the concern is not just short-term, it's how long can we collectively punish millions of people, totally innocent, for the crimes of a few over there, and still escape the ultimate blowback. And we can see what happened in Boston, which upset a lot of the country, and that happens every day in Baghdad or Iraq, tenfold, every day. Our next speaker is Sheldon Krimsky, who works in the fields of science, technology, ethics, and public policy out of Tufts University, where he's the professor of humanities and social sciences in the Department of Urban and Environmental Policy, and is an adjunct professor in the School of Medicine at Tufts. I've always found in reading many of his books, and he's written 12 of them, including Science and the Private Interest, How the Lure of Profits Corrupted Biomedical Research and Genetic Justice, DNA Data Banks, Criminal Investigations, and Civil Liberties. So those are two of his books. To be hard-hitting, intensely researched, but without fulminations. His 20-minute subject today is, quote, facing up to it. The science without law is immoral, and law without science is blindsided. Professor Krimsky.
Okay, thanks for staying. Science and law. Seems like two areas that seem to have different trajectories, but they share certain important ideas: evidence, causality, the advocacy system. It's obvious in law, and in science it's the peer review process, weight of evidence, false positives, reliability, facts, and conflicts of interest. All of those concepts are shared by these two traditions. But these ideas are interpreted very differently and applied differently in both of the systems. But law and legal education can no more turn a blind eye to the culture of science, even the philosophy of science, than science can avoid law. Both are intertwined in what I call a shotgun marriage. So let me begin first with the role of science in law and legal education. That law has to take the culture of science seriously became evident in the 1993 Supreme Court ruling Daubert versus Merrill Dow Pharmaceuticals. And law school, probably law students come across this case. Judges in the case were instructed by the Supreme Court to act as gatekeepers of expert witnesses. Prior to that, typically what would happen is prosecution and the defense would provide their experts, and the judge would be ruling basically on whether the expert was generally considered to be an expert in the field by looking at a resume, etc. But there wasn't really a very strict standard of judgment. But after the Daubert decision, judges are responsible for reviewing the scientific method of proposed experts before they testify to determine whether their analysis was relevant and reliable. In other words, judges have to decide whether the expert is a purveyor of good science or junk science. And for reliability, the expert opinion must be the product of scientific reasoning and methodology. That's a pretty big burden for somebody who attended law school. Under Daubert, corporate defendants who are sued for violation of environmental laws or toxic trespass can contest the plaintiff's expert witnesses before the trial even takes place, without a jury present. In other words, it's called a Daubert hearing. So before a jury trial, there is a Daubert hearing before a judge, which usurps the jury's right to hear the testimony of certain experts. If the judge decides we don't think this expert should meet the jury, then the jury never gets to hear the expert or the putative expert that is chosen. And there is a very narrow window to appeal the trial judge's decision in a Daubert hearing. And because such hearings are expensive, in criminal cases, there are far fewer challenges to the experts introduced by the prosecution. And in class action tort suits, Daubert hearings are dominated by corporate deep pockets. So with a lot of money and a lot of legal training behind them, the experts that are asked to testify before a tort hearing will be challenged by the defense, by the defendants, and quite often they are excluded from meeting the jury. The Daubert Court has given federal judges criteria to decide the reliability of expert testimony. Is the evidence based on a testable theory or technique? How or where in one's legal education does one learn about the criteria for whether a theory or technique is testable? And what is a theory anyway? Some people use the term theory rather pejoratively. It's only a theory. Evolution is only a theory. Has the theory or technique been peer-reviewed? Has it gained general acceptability within a field? Now there are scholarly law journals and scholarly science journals. The one thing you know about scholarly law journals is that the footnotes are correct. Nothing else, you can be assured of nothing else. In the science journals, nobody ever looks at the footnotes when they review a science, very few people even look at the footnotes when they review a science article. So you can be pretty sure that the reviewers of the science articles are looking at the content. But there is no peer review in law review journals, although a couple of law schools are beginning to think that maybe they should introduce peer review. Does the theory have a known error rate? Techniques have error rates, but not theories. There is no escape. Some knowledge of the philosophy of science and the culture of science must be integrated into the law curriculum. Otherwise, lawyers and judges will be blindsided by the actual operation of science, the peer review process, the status of theory, and the nature of scientific reliability. Even before Daubert, the need for science literacy in law became evident with the introduction of DNA evidence. In 1992, the first law clinic based on DNA evidence was started at the Cardozo Law School in New York by Peter Neufeld and Barry Scheck. Other clinics were modeled after the New York Innocence Project. I asked Neufeld how two lawyers with no science background were brazen enough to immerse themselves in the arcane area of genetics. Neufeld was a clinical instructor at Cardozo, and he realized that lawyers who had no science literacy were at the mercy of the prosecution. They moved from serology, the study of blood samples, to DNA. In 1990, Neufeld co-authored a Scientific American article titled, "When Science Takes the Witness Stand." He wrote, quote, "In courts of law, forensic testimony that goes unchallenged by a scientifically, often goes unchallenged by a scientifically naive legal community," unquote. He started a center on the interface of science and law. While Neufeld and Scheck had no special training in science or about forensic science or about genetics in law school, they created their own informal classes, refusing to be at the mercy of the new science of forensic DNA. They asked Eric Lander, a mathematician turned geneticist at MIT, to teach genetics to them, and Richard Lewontin at Harvard to explain population genetics and the meaning of DNA matches. They literally sat at the feet of these prominent scientists. Now, to date, there have been 311 post-conviction DNA exonerations in the United States. 311 people have been exonerated for DNA. 18 of these exonerations served time on death row. We're still trying to figure out how many people were executed who may have been exonerated by DNA. 193 out of the 311 exonerees were African Americans. Another indicator of the racialization of the criminal justice system. Those 311 innocent people served 4,156 years in jail that they shouldn't have served. This whole process wouldn't have begun had two New York lawyers thought that they had to immerse themselves in what was at that time considered to be an exclusively technical area that most lawyers would have just shunned away from. Recently, science has gone head-to-head with civil liberties and law. In King versus Maryland, recent case of the Supreme Court, the issue was arrestee DNA. States have laws allowing police to collect DNA of arrestees without a warrant, to hold on to the DNA even if a person is found innocent, and to keep it on the DNA databases. Now, without understanding the science behind DNA profiles, the analogy between fingerprints and forensic DNA profiles might seem reasonable and is often used. We hear about DNA fingerprints versus traditional fingerprints. While thumbprints have no familiar family ties, thumbprints do not point to ancestry or disease predispositions. DNA does. There is a significant difference between a forensic DNA profile and a fingerprint. In his minority opinion, and the case went 5-4 against King in King versus Maryland, Supreme Court Justice Scalia wrote, "The court's assertion that DNA is being taken not to solve crimes, but to identify those in state's custody, taxes the credulity of the credulous. Hard even to say, but unquote. He also wrote, law enforcement's post-arrest use of fingerprints could not be more different from its post-arrest use of DNA. So it takes a lawyer with some understanding of science to be able to embrace some of these issues that have come down through the Supreme Court and through other courts. Currently, there are 28 states in the United States that collect DNA from arrestees. And even if they're innocent, that DNA goes on the database. And they are under constant surveillance because every time some DNA is found at a crime scene, the police will put it onto the DNA databank to see if there's a cold hit. And if they don't get a cold hit, but something close to it, they begin investigating the family of the person on the DNA database, even though that person was never convicted of a crime. Another area where post-Daubert science testimony has been affected is in public health. Judges increasingly prevent juries from hearing epidemiological evidence of a toxic harm. Well, you know, the standard is epidemiology can't really give you causality. But animal studies, which can give you causality, are only about animals. So you're really between a rock and a hard place. And when there is epidemiological evidence, judges have adopted a principle called relative risk. Many judges accept as a threshold of reliable epidemiological evidence a twofold increase in the risk of health effects. It's become a surrogate legal criteria for more probable than not. So if somebody has an epidemiological study, but the risk compared to the control is not twice as great as the control, judges will throw it out. Most studies of the risks of passive smoke have an elevated risk, but not a doubled elevated risk. Medical risks like high alcohol consumption are often communicated to patients when the relative risk is less than 2. So the bar for introducing expert witnesses through Daubert has actually increased, and therefore there are barriers to toxic torts. Part of legal education should include insight into methodological norms that unless exposure to a substance doubles the risk of some diseases is not worthy of being heard by a jury. The methodological norms adopted by the courts, some would say, are social constructions rather than scientific facts. But when it comes to issues of toxic justice, these distinctions mean a great deal. It means that people who are affected by chemicals, who are exposed to hazardous waste sites, will not get their day in court and will not get a fair shake at justice. So if legal education needs some understanding of science, then science education certainly needs some understanding of law and regulations pertaining to science. Since World War II, science has been under increasing legal and regulatory authority, from the oversight of radioactive materials and chemicals in the laboratory to the regulation of clinical trials since the Tuskegee experiments, and more recently, regulations on conflicts of interest. Law and science treat conflicts of interest differently. In science, the primary antidote to financial conflicts of interest is transparency. But imagine transparency in law. So here's a judicial disclosure. A judge about to sentence a convicted felon makes the following disclosure to the courtroom audience. Quote, "I will be sentencing this defendant, who has now been tried by his peers, to be incarcerated in a for-profit prison in which I have an equity interest. The extra money I earn from this partnership between my court and a reputable penal institution helps to compensate my low salary and allows me to serve the public interest and render more thoughtful and objective decisions. Judge I. D. Clare." I cannot today imagine such a scenario, but it happens all the time in medicine and science. Moreover, there is a demonstrated funding effect in science. Private funded research studies yield different outcomes compared to studies funded by government and nonprofits. Most of the experts that are introduced by corporations are funded by those corporations. And those experts are beholden to the corporations when they testify. It's extremely important in the legal community to understand the biases that come about by experts being funded by corporations or by articles that are published in response simply to litigation. It's called litigation law or litigation publication. Harvard's law curriculum has very little that addresses the issues of how science interfaces with the law. There is one course on genetics and the law, and most notably focuses on genetic screening, and another course on law and forensic science. In the 377-page course catalog, there are 2 abstract listings with the term expert testimony, none with Daubert, 1 listing for forensic science, no listing for scientific method, no listing for reliability, 1 listing under genetics. 2 listings under genetics, 1 pertaining to animals and the law, and 2 listings for expert testimony. So I was asked to make some comments about why I thought law students, who someday may become judges, must have some appreciation and understanding of the culture of science, of scientific reliability, of the methods and techniques of science, of what a theory is, of what a reliable theory is, and of what consensus and peer review means in the scientific community. And without that information, they'll be at a tremendous disadvantage in any of these Daubert hearings. And with those disadvantages, many, many people will go without a jury trial. Thank you. Oh, yeah. Yeah, there are some materials on the table. There's a report that was done by a group of scientists and public health specialists called the Supreme Court decision, the most important Supreme Court decision that you've never heard of. There's also some books and some articles on the funding effect in science, which only until recently was disclosed and discovered, and which is why the scientific journals are now have conflict of interest rules, and why the government sets up a regulation on conflicts of interest in science. Any questions? Yeah. You saw, you get the microphone and repeat it for everyone? You saw
I was informed by someone I know well in the business yesterday that Google and Genentech are apparently going to have some commonality of interest. And I don't know quite what that is yet. I thought you might.
Well, 23andMe is a genetics company that will scan your DNA. And I think that there's a corporate relationship there between the person who runs 23andMe and somebody in Google. The most egregious conflicts of interest that I have observed in medicine have enormous effects on accepting drugs that are deleterious to people because they're getting enormous support from the drug companies. And recently, people who are in positions in public health schools, who are supposed to be public health scientists, and who are on the boards of chemical companies, and who are testifying against litigation cases, against plaintiffs, that certain chemicals might be hazardous, like asbestos, or on the board of the American Council of Science and Health, an industry-funded group that never has discovered a chemical it didn't like, except tobacco. I have to make one. They don't like tobacco, but other than that, in the 100,000 chemicals we have on the market, they've never found one that they thought was dangerous. So those are the most serious and egregious conflicts of interest. People at universities who now are funded by corporations and who are pushing out scientists in the public interest, those are the people who prevent these dangers from happening in our society, and they're the ones who are being pushed out of the university. Right, and I have to say that I must have been about 20 or 25 years ago. There was a young undergraduate at Harvard, and I'm sure that Ralph helped him on a project called Harvard Watch. And he came to me and we consulted on a methodology, et cetera, and he produced a very fine report. And then he graduated from Harvard Law School and worked with the International Monitor, what's it called? Multinational, thanks, Ralph. Multinational Monitor. And now he is the head of Public Citizen. Is that correct? Robert Weissman. And he and I actually, we published a paper on conflicts of interest. So this issue was one that has been around for a while. We've been working at it, and there has been more transparency over the years, but with transparency, that doesn't solve the problem of bias. That's just one part of the issue.
Thank you very much, Professor Princeton. Just a brief extension. Do Harvard Law students receive information about the moonlighting consultants of their professors? So if they're studying antitrust law, and what does the professor do for consulting with companies that are engaged in mergers? You might want to establish a protocol on that.